Oh, this case is very interesting. And if you look at it, if you look deeply into the Darlie Routier case, you can see exactly what their agenda is when they come out on social media and they say, well, this person did that wrong. That person wasn't certified, and they put this bag down right here, and they took pictures in the wrong way. They focus more on the procedures that the law enforcement and the medical staff made in Darlie's case. They're pointing the fingers at, well, they did this wrong, and the paramedics had to sit outside for too long, and this person didn't have that certification. That's what they're looking at. They're not looking at Darlie didn't do this crime because of this. They're not looking at reasons why Darlie is innocent. They're looking at everybody else screwing up. They're looking for a loophole to get her out. And in this particular writ, which she put out just after they did the change of venue to Kerr County, this shows where it all was sent to. I want to focus on a certain part of this writ that helps you understand the mentality of a Darlie Routier supporter and where it comes from. First, it just shows where it's all going, case number. Now, what we're looking at right here, appellant does not challenge the sufficiency of the evidence to sustain the conviction. The evidence and inferences viewed in the light most favorable for the verdict show that it shows what she did. She's not arguing the evidence or the sufficiency of that evidence. She's like, look, you got me. You got me, but look at what you've done over here. And just to move down just a little bit, just a quick look through it, take a look at that. Okay, I'll put this whole document in the description of this video, but I want you to think about this as we look. You're like, look, I'm not going to challenge you saying that I did this. There's enough evidence there for you to show that I did this. That's what that means. She's not arguing that. And they never argue the evidence. They argue loopholes. Especially Donnell. Oh, that James Cron, he was just a fingerprint guy. And this person wasn't certified. And Chad Patterson's son was a criminal. Or Jimmy Patterson's son, Chad, was a criminal. Or Glenn Mize down the road. Or this person did that wrong. Not reasons that Darlie is innocent. So let's take a look at that. Let's take a look at the thing that we have today is AI, and it gets most of the things right. But let's see what AI has to say about this particular statement. This legal phrase means that the appellant is not disputing whether or not there was enough evidence to support the jury's verdict or the judge's finding. Therefore, the appellate court will not review the evidence itself to see if it was sufficient, and the appellant must base their appeal on legal errors, such as a flawed legal process or incorrect jury instructions, not a challenge to the facts. The appellant is conceding that, even if they disagree with the outcome, the evidence presented at trial, if believed, would have been enough for a conviction. That means there is no reasonable doubt. Enough for a conviction. She even agrees to that. The appellate court's role is limited because the appellant is not challenging the evidence. The appeals court would not reweigh the evidence or determine if the jury got it right. The focus shifts to whether an error of law occurred during the trial, because that's all she's got. They'd be happy if there was a videotape of Devon and Damon being killed by Darlie, but the person that filmed the videotape had some kind of mental health problem or whatever, so the videotape is no good. They'd be happy to have her come home. They don't care. Common grounds for appeal. By not challenging the sufficiency of the evidence, the appellant might be raising other issues such as a mistake in the judge. She's looking for all this. Legal errors. Not factual ones. Fact. She killed those kids. The focus will be strictly on whether a legal error was committed. That's like taking the finger off of the guilty party and saying, look, I know this, but what about you? You're supposed to do it this way. You're supposed to investigate me like this. You're supposed to put this on the focus notes. You're supposed to write everything down. You're supposed to be taking notes. And you shouldn't have questioned me when I came out of surgery. And you did this and you did that and you did this. But let's not talk about what I did. Let's talk about what you did. And that's where they're at now with this case. That's where they've been at for the longest time. Keep that in mind when we're listening to supporters go on and on and on about James Cron, Tom Bevel, Max Courtney, Greg Davis, everybody's lying except for Darlie.